Good evening, everyone. Thanks for joining us tonight for another one of Strider's Professional Development Webinar Series. I'm Tara Sperzi, the CEO of Strider, and tonight I'm pleased to introduce Yvonne Ocrant out of Hinshaw and Culbertson Law, who will be speaking tonight on Equine Activity Contracts 101 with more than the paper/tablet that they are written on. For those of you who have not had a chance to meet Yvonne previously, you probably have seen her speak at several industry conferences. She's got a wealth of experience in equine law. She's spoken at the Farina National Conference, Dover Saddle Race. She was down in Wellington this past winter. She spoke at Ocala at the World Equestrian Center. She's a member of the Eventing Riders Association, a board member of the Industry Law Association. She's also a registered lawyer in Illinois, Wisconsin, and Florida. So she has been working equine activity law for over 20 years. She's got a diverse presentation to brief you on tonight. So as you have questions, which I'm sure some of you will, please make sure to use the chat function in the lower right to chat them over to Natasha Springers-Levine, our Chief Operating Officer, who's on the call. She'll be compiling everybody's questions and presenting them for live Q&A to Yvonne at the end of this. Yvonne will also have her contact information at the end of the presentation. Feel free to reach out to her directly. She is doing complimentary consultations for everyone who's been on this webinar, which is a fantastic resource. I think some of you know that she wrote the syndication partnership agreements for three of the four horses that are going to the Olympics right now. So she's definitely very familiar with the various legal issues involved in the sport. She's also very familiar with risk, being an eventing rider herself. She knows how to manage it. So without further ado, Yvonne, welcome. Thank you so much for joining us. Over to you.
So as Tara said, I'm a fellow equestrian. That's actually me on my, what we all call our heart horse. This was my horse of a lifetime. His name is actually It's All About Me. But he was an off-track thoroughbred that I took all the way to the one-star level and competed in eventing. And what that gives me is the benefit of knowing what you all are doing, what you're striving to do, what the day in the life of a horse owner is. And as an equine attorney, I can then speak to what the liability exposures are, so I can help you keep doing what you're doing with horses. Let's just do it a little bit better. We want to protect our sport, protect our passion, and keep ourselves out of the courtroom and on the horses. So that's where I'm hoping to get all of you, when you leave here today, to know a little bit more about what those risks are and how we can protect you from your exposure. You'll hear a lot of scary stories, and yes, you will be scared, but don't give up. And there is light at the end of the tunnel. We can definitely keep you doing what you do. So I wanted to start out by just quickly addressing what is equine law? What is Yvonne doing for a living? Why does she have a job? And how that can benefit you. Many of you have seen the black and white warning signs. You see them when you go to a facility and it says you ride at your own risk, and everyone says, well, if I ride at my own risk, how can I get sued? Why can I still get sued? And the reason you're posting those warning signs is because there's a statute in your state. 48 states currently have an equine activity liability statute. And most of those statutes say that those signs have to be posted for you to have liability protections. Okay, and we can talk about if you're from California or Maryland where they don't have a statute and what that means for you. But generally the states recognize there is a benefit to equine activities, whether it's financial, emotional, physical, but it's still a very inherently risky activity. So how do we encourage providers of equine activities to make that an option for us? We shift the burden of the risk. We shift the burden onto the participant and say the participant assumes the inherent risks. Okay, well, again, why does Yvonne have a job? Well, that's because those statutes also take away some of those risks in particular circumstances. So it's not important for you to leave here today reading the small print. That's my job. That's why I wear glasses now. And telling you what's in those statutes. What do they say in your state? But generally speaking, what I'm going to tell you is that each of those state statutes will tell you what is an equine activity. What are the inherent risks of engaging in an equine activity? And who's a participant? Well, why do you care what the legislature thinks? Because if the reason the person was injured was they were involved in an equine activity, they were injured as a result of an inherent risk of an equine activity, and they meet the definition of a participant, and you meet the definition of a sponsor or professional, and don't worry if you think you're just a backyard horse owner, that you have the liability protections. Well, what does that mean? That means that if the person was injured as a result of something that was not defined by the statute as an equine activity, you don't have any liability protection. If they were injured as a result of something that's not listed as an inherent risk of engaging in an equine activity under statute, you don't have liability protection. If that person doesn't meet the definition of who's of a participant, and you know who they are, they're the person standing by the gate at the warm-up arena, right? They're the person that gets run over by a loose horse. But even simpler than that, the statute says who's a participant. So if you were all live with me right now, I would ask you, who thinks that leading a horse into a horse trailer is a participant engaged in an equine activity? You'd all raise your hands, except anyone who's heard this presentation before. And because you're handling a horse, right? Makes sense. Well, I'm going to tell you right now that a majority of those 48 state statutes do not list horse trailering or leading a horse as an equine activity. So if the person got run over by the horse trying to lead them into the trailer, which is an exact case that I had in Iowa about 15 years ago now, the person was kicked by a mare being led into the horse or led into the trailer when her foal decided to leave, and that handler was severely injured. Well, the law says that that person was not a participant engaged in an equine activity. So the owner of that facility and the owner of that horse did not have the liability protections afforded by the statute. So the statute, as I said at the beginning, also requires the warning sign posted. Now, this sign I have here is just for fun. That's obviously not your warning sign. But the point being is that each state statute is going to have their own warning sign language posting requirement or in contract requirement. If you don't post the warning sign, according to the statute, if you don't have it in the contract, according to the statute, you do not have liability protections. So it's not important as we sit here today that you know everything that the statute says, but it's that you know that that statute will govern whether or not you have liability protections, and it may be on a case-by-case basis, but leaving here today knowing what you can do means that when your facts come to light because somebody gets hurt and they sue you, we will have the best case set up for you because you will have an equine activity in play. You will have that they were injured as a result of an equine activity, and you will have that they were a participant engaged in the equine activity, and you will have the proper warning signs and or the warning in your contracts that you're all going to use when you leave here today. So I hope that makes sense. I know Natasha's watching the chat room. And by the way, born and raised in Chicago, so I talk fast. I'm a lawyer, so we get paid by the word. We talk a lot. And I want to get you all through this material so you can get on with your evenings and decide how you're going to pick up tennis. So we can get through all this material quickly and get to your questions. So we now know how we get liability protections. We also know some of the loopholes, right? If we don't meet the definition of an equine activity, an inherent risk of an equine activity, and a participant, we don't have liability protections. The scarier thing is that, and I just kind of went through this slide really quickly. I get ahead of myself too. That's another occupational hazard. So bear with me when I get through material before I get to the slide. But what the equine activity also says, and that's at the bottom of the slide I just skipped through, is there are exceptions. So at this bottom here, it says list exceptions to the liability protections. So you come to me and you say, Yvonne, I have somebody who was hurt on my property. They were engaged in equine activity. They were a participant engaged in equine activity. So I'm good, right? I had my sign posted, I'm covered. I'm going to ask you, okay, well, what caused the injury? And if you tell me that it was due to faulty tacker equipment, right? The tacker equipment broke and that's what caused the injury. If you tell me that the result of the injury was because I put the beginner rider on the horse named Killer, I thought it might be fun. So we have a mismatch of the horse and rider. Or if you tell me that it was because the horse fell in a hole that I've known about for 3 months and I just never got around to fixing in the arena, you will not have liability protections. Those are the 3 exceptions. Even if you did everything right, if the person was injured as a result of faulty tack and equipment, a mismatch of horse and rider, or a dangerous or latent condition of the property that you knew or should have known about, you will lose your liability protections. The 4th exception is in willful and wanton disregard for the safety of the rider. we'll talk about that on a case-by-case basis, but that's really the catch-all that your injured person's attorneys will go after. And they're going to say, well, no, the tack wasn't faulty. The arena footing had nothing to do with it. The horse was a perfect match for her. The reason my rider was injured was because she said she felt uncomfortable and you told her to jump the fence one more time. And that was a willful and wanton disregard for the safety of my client. Well, anyone who's out there that's a professional and you figure out how to teach your students, if you took them off their horse every time they said they felt uncomfortable, you wouldn't have a client and your client wouldn't learn a darn thing. So as a lawyer, I have to educate the court on the difference between being a good riding instructor and the inherent risks of an equine activity versus that willful and wanton disregard for the safety of our riders. My favorite example, and my husband's my trainer, so that's the caveat, I can throw him under the bus, is if I'm not doing a good job in getting my horse to the right distance, he's going to throw the blue tarp over the jump. Why? Because that's going to give the horse something to look at. He's going to lift his feet up higher. He's going to do a better jump. Or he might slam on the brakes and throw me into it. So by putting that blue tarp over the fence, was that a willful and wanton disregard for my safety? Or was that just good training to teach the rider to be better or teach the horse to be sharper? So those are the kinds of fact patterns that I, as an equine lawyer, have to deal with in educating the court that what that was good training. That was not a willful or wanton disregard for the safety of my rider. So now that I got you completely confused, I'm going to tell you that what we can do to deal with these, let's call them liability exposures left over by the courts having to enforce these liability statutes, right? The statutes tell us how we're protected, but it also tells us how we're not protected. What the statutes also do or don't do, depending how you want to define it, they define who's a participant, right? I just told you a minute ago, the statute will tell us who's a participant. The statute's going to tell us what's an equine activity, and the statute's going to tell us who's engaged in an equine activity. What are those inherent risks? Well, why would we let the states define what's an equine activity? We know better. We know leading a horse into a horse trailer is an equine activity. We also know what the inherent risks are. I guarantee you the legislators that wrote these statutes don't know that horses are more afraid of squirrels than trucks. So an inherent risk of engaging in equine activity would be somewhat obvious to go to a court and say, well, a truck backfired and it caused the horse to spook and I fell off. Well, I could see a court understanding that, yeah, that loud noise, a horse's reaction, is an inherent risk. Well, when you tell a judge that a 3-pound squirrel ran in front of my 1,200-pound horse on the trail, and that's what caused them to spin around and drop and dump me and take off and run into the person behind me, the court's going to say, that's not what scared the horse, that was a squirrel. Now, if I can equate them to the cartoons where the mouse scared the elephant, maybe he'd understand. But we know that an umbrella can be scarier than another horse, right? We know that a bicycle is scarier than a loud noise sometimes, depending on the horse, and it can be the opposite. So what do? You say, that's great, Yvonne, you've completely confused me. Now I don't know what I'm supposed to do. Well, your contracts, all of these are examples of contracts that you should be considering in your, whether it's a business or it's you personally, to consider. Why? Because these contracts can tell the injured person's lawyer, hey, by the way, I know that you live in, I know you were injured in Illinois and you filed this lawsuit in Illinois, and the Illinois Equine Activity Liability Statute doesn't include trailering horses as an inherent risk. But guess what? I have a trailering release that your client signed that explicitly released me from liability for any injury to the horse, which you think, okay, Yvonne, that makes sense. What about an injury to the person who insists on loading their own horse into your trailer, even though you ask them not to? Oh, by the way, they have to use a carrot, right? And they have to stand underneath the horse because that's how they do it. And then, of course, they're going to get run over and it's going to be your fault. And leading a horse into a horse trailer is not an equine activity under the statute. But it is on the release that they signed, so you're covered. Also, if you missed an event or you missed a doctor appointment, and Tara and I were talking about this earlier, the trailering release will hold you harmless for any monetary losses as a result of the trailering or lack of trailering. You made the decision not to go. Now they're going to sue you because they missed the horse show and they couldn't go to pony finals. Well, I'd like you to have a release that says, well, that was my discretion. That was my decision. And you released me from that liability. The liability release will have examples of what scares horses. Anybody who lives in the Midwest knows that ice only falls off the roof when the beginner riders in the indoor arena. So that's what we're going to put in our liability releases, ice falling off of the roof. If you are at a facility where there's exotic animals, we're going to put a horse's unpredictable response to those animals, those noises that they make, the smells that they exhume. Judges don't know that. So let's put those examples right there in your liability release. So when that injured person goes to the court and says, Judge, I was injured because my horse was spooked by the kids riding ATVs on the property. And I didn't know that they were going to get spooked or that there were going to be ATVs on the property. Well, that would be fine under the liabilities, under the equine activity liability statute. But that liability release has ATVs specifically on your liability release because you know that there's a track next to your facility. So they're not going to be able to go to the court and say, Judge, I didn't know, I didn't assume the inherent risk of ATVs. Well, actually, yeah, you did. And it was explicitly in that liability release that you signed. Same thing with the share boarding agreements. And I'm going to go through each one of these a little bit. Each one addresses specific waivers of liability for you that the statute's just not going to cover. So as I said a minute ago, the liability release can do more than the statute, right? It can define who's a participant engaged in an equine activity. It can define the inherent risks. It can give examples for the court. What are the inherent risks that this injured person is going to assume? It's not always going to be the obvious ones provided by the statute. Here's another good one. The released parties. Who is going to be released from liability? I get so many samples where the released party is just the barn owner. Well, what if the barn owner has the right to use somebody else's horse to give lessons? Shouldn't we also release the owner of that horse? And why do you care? Not to say that you're not good people, but if the owner of that horse gets sued, guess what they're going to do next? They're going to come after you. So if you can get more of these foreseeable risks covered, you're protecting yourself. And I'm not saying you're not trying to protect the owner of the land that you're leasing, if that's, your situation you're in, but it protects you because if they don't get sued, then you're probably not going to get brought into some case. So let's define who is released by these liability waivers. Doesn't have to be just one person or one entity. Those exceptions I told you about, the faulty tack and equipment, the mismatch of horse and rider, I will candidly say not every judge will accept a liability release that tries to waive those exceptions, right? The court's going to say, look, that's the legislature's job. If they want faulty tack and equipment to be an exception, who am I? I'm the judiciary. I'm not the legislature. I can't change that. But if you have an experienced rider and they are responsible for tightening their girth or lengthening and shortening their stirrups, and they don't check the safety of that equipment, you might be able to overcome that exception. Why? Because your release said that the person who's signing this release understands the inherent risks of tack failures. And they assume the responsibility of checking their tack and equipment. Now, don't get me wrong, that can't be the responsibility of an 8-year-old first-time rider. But certainly our adult riders, and especially if they're using their own tack and equipment. So we can try to put some of those exceptions into our release as being waived reasons for the injury. Not the willful and wanton, that one's here to stay, but we can probably deal with the mismatch of horse and rider, that they've had an opportunity to try the horse, to ride the horse, to ask questions about the horse before they went and had their lesson. Maybe we can get around the mismatch exception. The release, hold harmless, defend, and indemnify language, that's going to be the same for all of our contracts. We want a release language, right? You agree to release me from liability. You agree to hold me harmless from any liability. Oh, and by the way, you agreed to defend me, right? So if the property owner gets sued and I get brought into this case, you agree to defend me. Yeah, I know it's your own case, but you still got to defend me. And indemnify, which means pay for your legal fees, settlement, judgment. Again, caveat, they're not all going to be enforceable all the time, but let's put those in there. Why? Because your contract can not only just protect you in the event of a claim, provide your lawyer with the defense that they need to say, hey, this injured person who's suing my client signed this enforceable release, but they may go to their lawyer. The injured person goes to their lawyer and they say, the first thing the lawyer should ask them is, did you sign anything? And if they show them this liability release that's well written, that's easy to read, that's clearly defining the inherent risk that this person's claiming caused their injury, and has this release, hold harmless, defend, and indemnify language in it, the lawyer, who, by the way, gets paid 30% of your recovery, might realize there might not be 30% to recover from. So you might deter somebody from bringing suit. If they can't get a lawyer because your release is so well done, you may have just avoided a lawsuit in the first place. Defining the loss is another provision you'll find in my liability releases. The types of loss that the plaintiff could sue for that they're agreeing to hold you harmless, right? It's not just financial. There could be other losses that they're claiming, missed opportunities. I'm not saying they're all recoverable, but people get very creative, and I say that loosely, when it comes to lawsuits and money. And a lot of lawyers try to get creative, right? So we're talking about future earning capacity. We were talking about money, like their medical bills, all these types of losses. But what if they say, you got to get me a new horse? You got to go buy me a new horse. Well, let's define all of their possible losses as being waived in this case. And then the ones on the right-hand side, I don't want to spend too much time on this because I really want to get to your questions, is the provisions that you will see in all of the contracts that I recommend. And why these are so important is these are the ones, again, that can either deter a claim or reduce your exposure. So reducing the claim time. In every state, there's a statute of limitations. So in Illinois, you have 2 years to bring a lawsuit for personal injury. Wisconsin, you have 3 years. Florida, you have 4 years. What your contract is going to say is they have 1 year to bring a claim, right? Who wants to wait? You don't want to wait 1 year, but who wants to wait 4 years to know if somebody's going to sue you for an injury? Again, caveat, not every judge will enforce them, but I have won cases on this issue, and you may even have avoided a claim because the time the person is injured and they go see their lawyer could be a year and a day from the time of their injury. They think they have 2 years in Illinois, right? They think they have 3 years in Wisconsin to bring their lawsuit. So they go to their lawyer and they say, I was injured a year and a day ago. And they say, no problem. We've got a 2-year statute of limitations. They come to court. I file a motion to dismiss. I said, they blew the 1 year statute of limitations, throw the case out. It's always an opportunity. Law, jurisdiction, and venue is an important provision. It picks the law that applies to your contract. Why do you care? Because if you teach in another state from where you live and someone gets hurt there, they're going to sue you where it's convenient for them. So you go to New York to teach a clinic, you come back to Illinois, they got hurt, they sue you in New York. Your contract is going to say not only does Illinois law apply, but if they are going to sue you for a claim that survives your release, it has to be in Illinois. Well, you may have just deterred another claim because they don't have a lawyer in Illinois, or they don't want to have to come to Illinois to bring their lawsuit. So now they might say, forget it. It's not worth the broken wrist, filing the lawsuit because I don't want to have to go to their state. You can also pick the venue, which is just the county. And again, there's reasons for that, but keep it convenient for you. Time, we talked about the time that they can sue, but the liability limits also applies in personal property damage cases. I guarantee you, if you are liable or somebody's trying to claim you're liable for injury to their horse, the horse they paid $3,000 for off the track is now $300,000 in value. Why? Because they're suing you. And if a lawyer's going to get 30% of recovery, he wants 30% of 300,000, not 30% of 3,000. So that's property, right? Horses are property damage. Your liability release can say, okay, if your claim survives the all of my liability protections, and you're going to sue me for the damage to your horse, your limit of recovery is $3,000. That would be an interesting outcome for them their lawyer to say, sorry, I can't help you anymore, or the case gets thrown out. Attorney's fees and jury waivers are just another provision that we can put in there to say that if in the American jurisdiction is everyone pays their own attorney's fees. You can put a provision that says if you get sued and have to defend yourself, they have to pay your legal fees. Again, the courts can have discretion on enforcing it, but why not put it in there to deter a lawyer from taking the case and saying, well, wait a minute, if we lose, we might have to pay their legal fees. Let's think about this and make sure we have a solid case. I'm not going to spend any time on the rest of these because I really got to get to the next slides, but the statute warning I have in the bottom is what I was saying about each state statute might require that warning language in your contract. So if you're looking at your samples right now and they don't have your state statute in there, I'm going to tell you right now, it's not enforceable. That's a simple way of looking at what you're using and knowing if it's enforceable or not, if you're in a state that requires it. And the signature. My one takeaway from this slide is if it's not signed, it doesn't work. So if you're going to use releases, get comfortable using releases. I told Tara and Natasha, I'm always surprised when I walk into a barn for the first time and they don't ask me to sign a release. You don't know me, and I want to know you're a professional. So I expect to sign a release, whether it's enforceable or not, that's another day. But always use them, and they cannot be signed by minors. I don't care how cute they are or who tells you they can. Minors cannot sign contracts. Got to be signed by a parent. And you'll see on my releases, the signature line is by the parent on their own behalf and on behalf of the minor child. Because who's going to get hurt? It's not going to be the minor child. It's going to be the mom. So don't accept releases signed only by the parents on behalf of the child. It's on their own behalf and on behalf of the child. So again, I mentioned earlier a few minutes ago about trailering agreements. The provisions that I would typically include, not just identifying the horse and the parties, but the same release and hold harmless language we talked about, that they're releasing you from injury to the horse and any other property they might be throwing into your trailer, their attacking equipment. They're releasing you from any negligence or other fault. The risk of loss, and again, that's similar to identifying what the inherent risks are of trailering. The inherent risk of horse behavior, they could injure themselves. They could be injured by the other horse. They could damage your trailer. You want them to agree to hold you harmless and agree to be responsible for any damage to your trailer. It's up to you if you enforce it or not, but let's at least give you a contract that says you're entitled to recover that. The owner should warrant the horse is safe to travel. I just think that's good practice. That you have the right to refuse to transport. And we talked about that earlier, like what would be the reasons why you'd want to say, look, we're not going, and they'll hold you harmless from that. And they have to give you emergency authorization, right? You're in the middle of a highway, you have an accident, you want to know you can authorize treatment for this horse and you're not going to get sued for it. Those are those little, I have to do the gosh forbid situations, the hard questions. So let me put that in your contract so you don't have to think about it if something should happen. Your share boarding agreements, again, we can spend more, I could do a whole hour on every one of these contracts, but some of the things you want to look for and make sure are included is the term of the lease. How do you get out of it? How does either party get out of it if you want them to? What's the amount of the lease fee? And is that going to be reimbursable under any circumstances whatsoever? I litigate more questions on the reimbursability of a lease fee because they get terminated early, or the horse gets hurt and they want to return the horse. Is that lease fee reimbursable? Probably not, but you got to put it in there. Any restrictions on how they can use the horse or where they can board the horse? That's also highly litigated. If it's not in your contract, assume it doesn't exist. The he said, she said, the judges don't know what to do with it. And let's make the judge's job really easy to find in your favor. Anything that's important enough to you needs to be in this contract. So if you want to restrict their use of the horse or where they're going to stable it or giving you notice of moving the horse or who they're going to train with, put it in the contract. The care and maintenance that you expect of your horse, if you're the one caring for the horse, I have a provision in there that says what your responsibilities are. Because if it's not everything, it's got to be in the contract what the limits are of the care and maintenance of the person leasing the horse, or if you're the one who owns the horse, what do you expect? Again, I want the person who's taking on the lease to assume the inherent risks of engaging in equine activity. So everything you saw in that liability release would be in this section as well. And what do you expect for incident reporting? If you own the horse, when do you expect to be notified of an injury or an illness? Is it at the moment? Is it within a certain amount of time? Do you need to give prior authorization for any kind of emergency care? It's got to be in there. It's got to be reasonable because you don't want to set them up for failure. But if you're the owner of the horse and you want some kind of a notice, we got to put it in there. Title always stays with you as the owner of the horse. We want to make sure that's in there. And the relationship of the parties is lessor and lessee. They're not your employee. No one's anyone's employee. So that if someone gets hurt, they can't come back and sue you and say, oh, well, this person was your agent or this person was your employee. I know it sounds very academic and you're saying, well, nobody would think that. They will get very creative when they think they're losing. They're going to find a way to bring you back in. Same thing with purchase and sale agreements. My advice to you as your lawyer is going to be different in parts, depending on whether or not I represent you as the buyer or the seller of the horse. There's going to be things I'm going to want you to put in there as the seller, you know, that there's no warranties, no takebacks, no guarantees, you know, last and final, all the stuff you could think about. If I'm representing you as the buyer, I'm going to be more careful to say, hey, I want it in here that if the horse comes up lame within the first 6 weeks because of this OCD that you said is no big deal, that I can bring the horse back for a full refund, if that's the deal we make. Do not allow those important terms to be on a handshake. I'm even saying, you know, of course, text messages and emails I use as evidence all the time in cases. But if you know that that's a term, let's put it right in your contract. I'm hoping what you're seeing from this, and I'll remind you again at the end, why form contracts don't work. They don't pick the right jurisdiction. They don't have all of these quirks that can be to your benefit, you know, listing what the inherent risks are, listing in this example, what are some of the disclaimers or disclosures about the horse's pre-existing condition. That's not going to be in a form contract. That's not going to be in the one that your friend gave you to use, that she uses for all of her horse sales. So let's make these particular for you. You'll definitely save money in the long run by investing in it on this front end. If you're expecting a commission on a sale, that is, again, one of the most highly litigated issues. It's got to be in the contract. How is that commission going to be calculated and who's responsible for paying it? Boarding agreements. I said this earlier about leasing agreements. It's very similar. If it's important enough to talk about, it should make its way into the contract. What boarding service, if you're the boarding facility, what services are included and which ones are not included? If you are doing turnout, is it going to be group turnout or solo turnout? If there's a chance it's going to be group turnout, I have an entire section of the inherent risk of horse turnout, right? Horses can be horses. Horses do stupid things, especially when nobody's looking and nobody's talking when it comes to who did wrong. That's why this picture, I think, is so appropriate. Horses have a way of injuring themselves and nobody ever knows why. Well, if you're the barn owner and you're going to turn horses out in groups, you're going to be very careful to make sure they all get along, but you can't guarantee it. And so your horse owner has to hold you harmless for any injury resulting from the inherent risks of turnout in group arrangements. And if they don't want to release you from that liability, first of all, that's a red flag that maybe they shouldn't be your client, but that horse doesn't go out in a group turnout then. And they have to pay extra for solo turnout. That's the way it's got to be. Why? Because your lawyer said so. Your insurance company said so. Blame it on whoever you want. If you're a barn owner and you're worried about getting paid, and you should be, there's specific lien provisions we can put in your contract that says if the board's not paid, and don't ask me, do I have to wait 60 days? No. If the board is not paid, you can give them a 10-day window if you want, but the statutes read that from the moment you're owed money, you have a lien on that horse. Also, don't come to me a year after they haven't paid board. Right? Let's get these enforced while you're 30 days out, 60 days out. Trust me, I'm the worst when it comes to giving clients time to pay their bills. But at some point, that horse won't be worth as much as what you're owed. And when I help you through the lien enforcement provisions of selling that horse for what you're owed, you're still going to come out behind. So stay on top of being owed, knowing that the contract that I write for you has a lien provision and that says you have put possessory lien on that horse. It does not leave until you get paid in full. The facility rules, you know, put in the contract specifically that they have to follow the rules, which can change from time to time. You can put them some in there, you can not, but they can change from time to time and they agree to follow them. That they agree to sign your liability release, and anyone that comes onto the property with them or their invitation has to sign your liability release. I skipped over termination, which I know is an important point. People say, well, do I have to give 30 days notice? That's typically the industry standard. But if somebody is, I'm sorry, people are bigger pain in the ass than horses sometimes. If somebody is just what I call an undesirable boarder, you're not going to want to wait 30 days for them to stir up more trouble. So there's going to be certain exigent circumstances where I want you to have a 48-hour notice out if that is something that you're concerned about. So we have a provision in there for certain circumstances where you can just give them 48 hours notice or 72 hours notice that they have to relocate. If they're going to store property, you know, they're attacking equipment, you're going to have a release in there for any damage to their equipment. There's no insurance for their horse. A lot of my boarding clients get this question and they say, well, don't you have care, custody, and control? That is not insurance for the horse. That is insurance. If somebody's horse gets hurt and they sue you, the insurance company has money that they can offer to that injured person. That I call it walkaway money. I know it's a terrible term, but the idea is, what will it cost to make you go away? And if you can offer them, it's a $5,000, $10,000 care, custody, and control, they might take that, right? Rather than going through all the hoops that I told you about, the jurisdiction, the lawyer that's going to want 30%, having to spend 2 years in court to prove that they were a participant engaged in an equine activity. they might take that 10 grand and move on. So that's what your care, custody, and control insurance. It is not insurance for their horse. So your boarding contract is going to say, we do not carry insurance for your horse. You are strongly encouraged to carry your own mortality and major medical and liability insurance for yourself. And then we have the same warranty and disclaimers that we don't guarantee the condition of the property or the safety of your horse while we'll, do our best. And then the emergency care, I consult with clients on whether or not you're going to have the discretion for not only emergency care, but euthanasia if the owner can't be reached. It's something to keep in mind because you unfortunately may find yourself in that situation. I think nowadays it's a little better with cell phones and all that. But if the person can't be reached, not only do you have the authority to call the vet, but if there's a euthanasia decision that has to be made and you're standing there with the horse with a broken leg and you can't reach the owner, I don't want you as the barn owner to be put in that situation of having to make that horse suffer. So that's an added I've put into my releases. Training agreement, same notion. Again, I'm going to go a little bit faster here to get to your questions, but I get a lot of clients that say, do I need a training agreement? Well, of course, my answer is yes. Do you have liability exposure? Then let's talk about a contract. Why? Because you're in the best position to make the training decisions for this horse, right? Well, when that horse, God forbid, gets hurt or falls down, guess whose fault it is? It's going to be yours. And guess what they're going to say is, whatever training tool you used, I didn't say you could use that, right? The horse flips over from side reins. Oh, I didn't tell you you could use side reins. Or the horse gets a rub mark from your spurs. I'm not talking about bleeding, right? I'm just talking the hairs worn away. Well, you've abused my horse. I see spur marks. I didn't say you could use spurs. So I know it sounds ridiculous, but I'm giving you real life examples. I always say I don't make this stuff up. Okay. So when you have a training agreement in place and you feel that you want to be protected from the training mechanism, especially if you're taking a horse that needs to be fixed, you're going to be doing the tough love. I don't want, a happy horse owner to be standing there saying, oh my God, oh my God, oh my God. I want you to have that discretion and they agree to hold you harmless. If the horse needs to be trailered, think about having a trailering agreement in place, or we add that provision to your training agreement. If you decide not only for training and you might need to compete the horse, right? Or you want to go to a clinic with the horse might need emergency medical care. Got to throw it in your trailer and take care of the horse. That can be in there. If you want to terminate this training agreement, let's have an exit strategy for you. If it's just not working out or the owner's again becoming the bigger problem, I want you to have an out clause. I want you to have a lien right on that horse. You've been taking care of this horse for 6 months and putting in all this training and you haven't been paid. Okay, well, I'm not leaving, this horse isn't leaving my property until I get paid. Same thing about emergency care. You want to know that there's disclaimer or that they disclose the horse's health care coming into your facility. They're not bringing in strangles, all of its horses up to date on its vaccinations, all that good stuff. I say this really fast and I say it like it's obvious. The point is if you have a handshake deal, you don't have any of this. You don't have emergency care authorization. You don't have warranties that the horse is up to date on its vaccination. You don't have a disclaimer that you can choose the training methods on what you want to do. And you also want to, again, say that you don't provide insurance for the horse. It's possibly a care, custody, and control arrangement. If you're going to own horses in partnerships, there's various types of partnerships that I work on. I do partnership agreements where it's your one-on-one, person to person. I put together syndicates. 3 of the 4 horses going to the Olympics are horses that I've syndicated. And I don't say that for chest beating. I say it to say that these can be everything from your horses to Olympic horses. The format is the same. The work that I do is the same. It's so important to get it in writing if you're going to do a deal with somebody else involving your horse, because these topics that I have listed here are examples of reoccurring reasons for the breakup or the legal dispute, especially when it's a verbal agreement. So the best thing about putting these contracts in writing, especially the partnership agreements, the training agreements, sometimes even the boarding contracts, is if you're going to have a dispute with the client, do it in the honeymoon stage. Figure when everybody's happy and excited about getting together, let's work out the ownership percentages. Let's work out who's going to pay for the expenses. Let's work out how we're going to divide the prize money. If there's an offer to buy the horse, who makes that decision and how does the money get paid out? Who's going to care for the horse and where? Let's work that out when we're in love, not when we're trying to break up. So getting that in, and I say that very, flippantly, but it really is that kind of a relationship. When you're dealing with a horse, it's like dealing with children. It's very emotional. Everyone's very tied to it. Getting it in writing helps the parties identify where they needed to work things out that they might not have even known on a handshake deal, right? Oh, you know what? I assumed we were going to split the expenses 50-50. But then you find out the other person expected it to be 70-30 because they brought the horse to the party or whatever the reason is. And then the other person says, oh, that's totally fine. I just assumed it was 50-50. Well, you would have made a big mistake if come, time to sell the horse and now you're dividing up the profit or the sale proceeds and you find out that person expected you to pay more. So let's get all that worked out in the beginning of a partnership. So here's my 5 takeaways. I apologize if I skipped over any, but so I'm going to use this opportunity to wrap up. If you didn't hear a word I said or fell asleep or you're totally overwhelmed. And I can certainly make these slides available for Strider to provide to you. But I want you to broaden your liability protections, right? The statute doesn't do enough. A handshake deal does not do enough. So let's put it in writing and make it better for you than the law can provide. Don't use forms. Forms do not broaden your liability protection. The forms are not compliant with your state statute, right? A form for Illinois from Wisconsin is going to have the wrong warning sign in it. A form from New York is not going to have any warning sign in it at all. So make sure the form is enforceable under your applicable state law. The only way to do that is to have it drafted for you. Get it signed. And I probably should have mentioned, I struggled to come up with an acronym for you to remember all this. So it's a horrible one. It just says bag it. But by broadening your liability protections, avoiding forms, getting these contracts signed, that's your bag. So that gives you a starting point on what you need to put away those liability exposures. The I is invest now. And I mentioned that earlier, and I mentioned that to Tara, and she thought that was a really important point to remind everybody that investing in these contracts now, I will guarantee you, this is one thing a lawyer can say 100%, and no lawyer can say that about anything else. It will cost you more to defend yourself than these contracts will cost you to create. And they will provide you with a defense. I'm not saying they're going to pay for your legal fees, but they will provide you with a defense. They might help you deter a lawsuit being filed in the first place, right? The value of that is $1 million. And they might minimize your risk. So even if you do get exposed to liability, we may have reduced your $300,000 horse loss claim to a $3,000 claim. So investing in that now and investing in the advice that I can give you, I think is going to pay you back exponentially. And then the T for bag it is, I mentioned a couple times using this honeymoon stage phrase, is testing it by using these contracts. It really tells you who your red flag clients are. If a client quibbles over something that should be a really easy decision to make, what are they going to be like when the horse has a bad day, or when the expenses exceed what everybody thought, or in a boarding agreement, or sorry, a share board agreement where you all agreed like on, yeah, you can use that trainer. And then they say, well, I want to switch trainers. And you say, no, I don't want you to switch trainers. Well, if the contract says they can't switch trainers, we have a contract we can rely on, rather than we get into a debate now on whether or not you can change trainers. I mean, that's just ugly. That's not good for the horse. It's not good for you. So these are some of the terms that we can say, look, if you're going to change barns, I want to be notified in advance. And the person says, well, I don't have to tell you where I'm boarding him. I'm leasing him. I don't have to tell you where he goes. Sorry, this lease isn't going to work. If they're not willing to tell you where their horse is, this lease is not going to work. So test your contracts by negotiating those terms in that honeymoon stage, get it in writing. And the final point about that is I have clients who they agreed all the terms, they send me all the terms in like a bullet point format, I put it in writing. Once you see it in writing, sometimes there's things you didn't think of. You know what, now that I read that sentence, it reminded me, I wanted to put in there that they couldn't jump over 4 feet, right? It just made me think of it. So let's put that in the contract. So sometimes it can actually help you do a better contract by putting in writing. So that's the testing your honeymoon stage reminder. So I am going to open it up for questions. I think we have a good 15-20 minutes for that. But the last point I wanted to offer to all of you, again, as a thank you to Strider for making this available, is a free consultation. So you just heard me spew off everything you need to know, and you're going to forget all of it. Okay, Yvonne, I want to start a boarding operation. What do I need? And tell me why, and tell me what else I'm forgetting. That's the one-on-one time, and there's no charge for that, because I'm not going to draft you a contract you don't need. And I don't want to draft a contract that's not written for you and what you're doing. So I need to know more about what you want, what your concerns are, what kind of exposures you have, so I can recommend the right types of contracts, and then draft the provisions that are needed for you and your operations. I'm reducing my hourly rate. So my standard rate is $450 an hour. Anybody who comes through Strider is going to be $350 an hour. And the contracts themselves will be done as best as we can on a flat fee. So after we talk and we realize what we need, you're not going to be on an hourly basis unless we have some, some certain circumstances. But the contracts, for example, that I can tell you right off the bat, the liability release, mine is a one-page document. Why? Because I think from an enforceability standpoint, there's no page 2 that they said they didn't see. There's no judge that's going to say they couldn't have read it. So I keep my contracts, my liability releases to one page. You pay $350. If it takes us 2 hours, if it takes us 4 hours, which it won't because I've done so many of them, but I know that I want to encourage you to come into my door. So I take this liability release very seriously enough to say it's a loss leader for me. So anyone who knows marketing to say, you're willing to do this at a loss because it's that important to get people to appreciate using contracts and be comfortable with it, that I want you to do this as a fellow horse person, as a protector of the industry. So if you say you want a liability release from scratch because you don't have one, if you want me to review the one you're using, usually it's easier for me to draft a new one, but we can take a look at yours at no charge. We will get your liability release done for you and buttoned up for that one-time $350. The rest of them are usually going to be 1 or 2 hours. Like I say, depending on the extent of them and how specific they are for you, you're looking at, between a $350 and a $700 to $1,000 investment. $1,500 would probably be the max to get all the contracts that you need. That's just been my experience with setting up newbies. So take advantage of this opportunity. Another thing I can guarantee you is no lawyer will have the experience or the budget that I'm providing to you to get this done for you. That's how passionate I am about it. So as Tara said, my contact information is provided here. That's my office number, which goes to my cell phone. There's no hiding these days. So anywhere you call me or email me, I will get it. I will get back to you and we will set up our one-on-one time to get you taken care of. So with all of that, thank you to Strider, to Natasha and Tara for making this possible. For all of you who gave me your time this evening, I hope you found it valuable, informative, maybe a little bit entertaining, and keep doing what you're doing. Let's just help you do it better.
Yvonne, thank you so much. That was super informative. And just so everybody knows, we will send the slides out in a follow-on email. So you all have this recording and the slides as backup if you want to reference any information. But we'll also be sure to include Yvonne's contact information in there so you can get in touch and take advantage of the consultations and expertise. So with that, we did have a couple of questions come in as you were speaking. So I'll kind of run through those. And if anybody still has questions, please drop them in the chat, either to me privately or to the group. And we can discuss some things as we roll through the last few minutes here. So in terms of a sales contract, do people typically do sort of a hold harmless or something like that language for a horse's lifestyle change, right? So if a horse leaves the barn and training program that it's in, it can change behaviors. Are you seeing litigation related to that? Do people include language like that? Is it helpful?
Yeah, so it's a great question. I'm seeing a lot of litigation, unfortunately, not just disputes, people trying to return horses after they buy them, or even a lease arrangement saying this wasn't the horse you sold me, or this isn't the horse that I leased. And again, the courts don't know that horses' behavior can change. And so when they say that I bought this horse and the seller knew that I was a beginner, and yeah, I tried the horse and he was great. I got on the mounting block and put my leg over and he walked off like a gentleman. And then as soon as I got him back to my barn, he took off from the mounting block, and it was like literally the second time I rode him. And, you sold me a lemon, he must have been drugged. I don't know what. Well, what they're not appreciating is that the horse went from a facility where he had nobodies, and all of a sudden there's 30 horses on the property. And every time she goes to get on the mounting block, the sprinklers are going and the landscapers are mowing the lawn behind her. And oh, by the way, there's always a cart with, a horse with a cart attached to it in the next door arena. They don't tell the judge all of that. And so what I encourage people is that these sale agreements and even these lease agreements have a disclaimer in there that says horse behavior can change from differing variables such as new feed programs, locations, training programs, tack and equipment. A bad trailer ride created ulcers. It can be any behavioral change that did not pre-exist the sale that might present itself, and you, the buyer, agreed that you've had an adequate opportunity to try this horse for your purposes, and you agree to buy the horse as is with no guarantees about behavioral performance. Now, I just viewed that off the top of my head, but those are the issues that I end up litigating, and so I'd like to take that away. Now, there's no guarantee that that contract is going to carry the day, but it'd be certainly nice to tell a judge, we had this discussion. And it's in there. And if they're a long-term horse owner, they know that, and I can prove that. If they're a first-time horse owner, it's in the contract. So either way, they were made aware of this. Another important protective measure in your sale contracts has got to be, and I know it sounds, everyone knows about the as is, where is clause, right? No takebacks. There's got to be more to it. There is no refund whatsoever under any circumstances. There's got to be more detail, because the where is as is, all they're saying is, yeah, but you sold me the horse that you represented to me. You were lying in everything you represented to me. So I'll put things in the contracts like how many trial rides they had, where those trial rides took place, that they had an opportunity to take the horse to competition and chose not to. Like, as much as you can put in there to say they had the opportunity to go head to toe with this horse on and off property, and either they did and it was fine, or they chose not to. And so the behavior they're complaining of now could have been tested, and they chose not to. And I have zero experience with that behavior. So there's no way I knew or should have known about that to disclose to them.
That's very helpful. So with that, are you seeing more sort of action and litigation on horse sales or rider injuries? Like, what's the most important thing to protect against, I guess?
Yeah, so with COVID, it's a little tough to tell because it's been about 1.5 years of court closures. But now that it's picking back up, and because there wasn't as much riding activity, probably didn't have as many injuries, but there were a lot of horse sales. And so for a while there during COVID, I was getting a lot more litigation on horse sales. But I unfortunately, it's the nature of the industry. The more riding, the more accidents. It is a very litigious society. I will tell you that in the United States, there is no hesitation to file suit. Now, you and I would sit here and say, I would never sue somebody for falling off of my horse. But there is a large group that would. It's just, we can't predict crazy. They're out there. And so a lot of European buyers won't sell to, or sellers won't sell to the United States because of that, because we're so litigious, or they won't train in the United States because we're so litigious. So the litigation is out there. It's always a possibility, but I can't say that there's more of one than the other, because it's your riders that are suing for injuries, and it's your dealers, people buying horses, that are suing for horse sales. But I was telling you guys when we talked earlier that I'm sensing a new industry of shifting blame. It can't be my fault I fell off. It can't be my fault that I fell off the horse because you sold me a bad horse, or I was injured because of somebody else's fault. I think there's a lot of blame game going on. I don't know if it's egos. I don't know if it's sense of entitlement. I don't know if it's because they weren't told no as a child. I don't know what it is, but I'm seeing a lot more of it was somebody else's fault, whether it's a bad horse sale or an injury. And unless they get settled out by insurance companies early on, they're going to make their way into the courtroom.
Yeah. So one question that came through related to releases again, is there an ability to cap potential financial damages or loss in a release?
That's a great question. I mentioned earlier about limiting the exposure for property damage, so the horse being injured or the value of the tack and equipment. We can cap that. We cannot cap personal injury. So if you see a release that says you cannot recover more than $1,000 for your injuries, one, that would not be enforceable, and two, a judge might decide that your whole release is unenforceable. Now, I do put a provision that you saw that word severability in my slide. That's a sentence that says that in the event that the court or the decision maker finds that a provision is unenforceable, that the remainder of the contract remains enforceable. Because I draft that in there, which I would never put the $1,000 cap on personal injury for the reason I just said, but if the court for whatever reason says, look, you picked New York law applies, and I'm saying New York law doesn't apply, that doesn't mean the whole contract is negated. He can blue pencil, which is what they call blue pencil, strike that out, and the rest will be enforceable. But it's not, as a lawyer, I cannot advise you to put in a provision that I know is not enforceable. One, because it's bad practice, but two, it could negate your entire contract if the court finds that you've gone too far and now he's mad at you, right? So he's not going to help you out by enforcing the rest of your release.
Yeah, okay, makes sense.
And to your point, or to that question, Natasha, since we know we can't limit personal injury exposure, and we're doing the best we can with an enforceable contract, the other protective measure that has to be taken into consideration is insurance, because it's the insurance that's going to pay for that lawyer to defend you. It's the insurance that's going to pay for any settlement. It's the insurance that's going to pay any possible judgment. So knowing we cannot limit the personal injury exposure, it's important to consider what insurance is available. If you're a professional, you have, commercial liability insurance policy. If you say, well, I'm just a horse owner, I don't have a business, there is insurance called personal horse owners insurance. And I think of that for myself because, I feel like I got to talk or walk the talk, is that if I fall off my horse and my horse runs somebody over, if I was negligent in causing that injury in some regard, maybe I was riding somewhere I wasn't supposed to, they could sue me personally. So to protect my personal assets, I'm going to have personal horse owners insurance. That's the liability insurance for myself. It has nothing to do with major medical or mortality on my horse.
Got it. Okay, that makes sense. That's good information too about sort of the legal aspect and the insurance working together so well. Well, I think that was all of our questions. So last call for questions if anybody wants to drop them in the chat. And if not, then Yvonne, thank you so much. And we really appreciate your time. Tara, did you have anything to add?
Thank you all for attending tonight. Yvonne, thank you so much for taking the time to speak with everybody tonight. I know I certainly learned a lot, as I think everybody else did. I'm definitely going to be calling my insurance agent after this and getting a few more insurance policies out there. So thank you so much for joining us tonight.
You're welcome. Thanks for having me. Everyone have a good night.
As well.